America, I have bad news. The Moore v. Harper case pending before the Supreme Court is now up in the air, putting in jeopardy the voting rights for potentially millions of Americans, as the North Carolina Supreme Court has done the absolutely unthinkable. As you may remember, Moore v. Harper is a case pending before the Supreme Court as an appeal to a North Carolina Supreme Court decision known there as the Harper v. Hall case about some outrageous redrawing of congressional district maps. But more importantly, Moore v. Harper proposes an obscure legal theory called the independent state legislature theory that basically says that no court has any jurisdiction over the legislative powers on federal election laws. In other words, according to that theory, all laws that govern federal elections are created by state lawmakers, and nobody, not the state courts, not the governor, not even the state constitution, can challenge those laws. So imagine the most partisan gerrymandering process that abuses the power of a state house supermajority, not an impossible scenario nowadays, as a means of securing lasting power for that body. That, according to this theory, would not be challengeable by anyone. So understandably, the North Carolina Supreme Court in the famous Harper v. Hall case had rejected that theory, and the party that lost then took that decision up to the United States Supreme Court. So that case was now pending before the United States Supreme Court, but the North Carolina Supreme Court, whose justices are elected officials, recently became a majority conservative bench, and they got together and did what is hardly ever heard of. It decided that it would rehear the very case that the previous Supreme Court of the state had heard. They just took it upon themselves to do it, and today they decided. And that decision that you see behind me is that the Supreme Court overruled itself. It basically said the previous Supreme Court made a mistake. We now allow the gerrymandering, the redrawn map as they were presented. We allow the independent state legislature theory. What does that mean? That now North Carolina recognizes full, unhindered power by the legislative to gerrymander however they want, to change the rules that govern federal elections in that state however they want, with anybody being able to say anything at all. But as importantly, it means that this case, the one pending before the United States Supreme Court, is up in the air. Why? Because the party that originally asked for relief to the U.S. Supreme Court now got what it wanted from the North Carolina Supreme Court, which could make the U.S. Supreme Court a moot case. What does it mean for the rest of the United States? It means that we could be witnessing the beginning of a disenfranchisement process, the likes of which we haven't seen since the Jim Crow laws.